All right, good afternoon, everyone. Welcome to the Contractor Development and Bonding Program presents new laws for contractors in 2022. We're excited about this workshop. We have our good friend of the program, Colin McCarthy, here from Lanak Hanna, who's going to give us an informative program and a presentation this afternoon. So just want to make sure everyone is involved and paying attention. I have a couple of housekeeping notes. You'll probably seen this before if you've been to one of our workshops. So just bear with me for a minute or two, and then we'll get to the reason why you're here this afternoon. So what you should know for today's presentation. The main thing is, if you want to ask a question, we're going to encourage you to raise your hand and ask them verbally if you can. We want to create that human interaction that we're so missing across this virtual medium, right? So that's what we want to do. We will take them in the chat, but we prefer to hear your voice and hear your question that way. Your camera and microphone, we would love for you to be on camera. If you've done a presentation on Zoom or any virtual platform, it's really hard to talk to black boxes with names on them. So we want Colin to be able to see some faces, see people nodding, smiling, shaking their head if they disagree, whatever it is. We want him to have that human interaction if possible. Be aware of your surroundings when you are on camera. Make sure if you have to get up, feel free to turn your camera off or anything like that. And then last thing, and the main thing is enjoy the presentation. Just be an active participant, ask questions, anything you have that you may want to ask or know, feel free to ask that question. All right. Then sometime throughout the presentation, I will put this link for a brief survey in the chat, just to asking you to let us know how the survey, how the presentation was. And if you enjoyed it, if you didn't enjoy it, whatever your sentiments are about that. It'll only take you about 2 minutes to do. So we want you to complete that. And then lastly, this is how you get in contact with us. We have our phone number, email address here, our website, and then follow us on social media as well, as you'll be able to get updates about new events and things that are happening with the Contractor Development and Bonding Program. And also, if you are not a member or enrolled in the Contractor Development and Bonding Program, one of our account managers, Rosa Azorio, is here this afternoon. If you want to learn more, just send her a private message and she can help you or get in contact with you and let you have some more information about the program and what we provide in addition to trainings like this. So that's enough of me talking. I'm going to stop sharing my screen. Any questions about what you guys heard so far this afternoon? No? Okay, good. I did a good job, right? Great. I see some smiles. Good, good, good. All right. So without further ado, I want to introduce Colin McCarthy from Lanak Hanna, and he will get us going for today's presentation. So it's all yours, Colin.
Okay, Carlos, thank you. Good afternoon, everybody. As Carlos said, my name is Colin McCarthy. I am hopefully everybody can hear me. If not, someone will say something. I am a construction attorney down in Orange County. I've been a construction attorney for 20 plus years. And what does that mean? Well, the short elevator speech part to that is I help contractors solve problems and manage risk. So solving problems is almost the easier part. Managing risk becomes the harder part. So one of the things we're going to talk about, sort of the theme today in managing risk and solving problems, is this sort of every year, the annual event in January and February, or what laws did Sacramento bring to us to make our lives more wonderful? I say that sarcastically. We are all business people, and unfortunately, most of the laws coming out of Sacramento are not in favor of businesses, particularly smaller businesses. So every year when we do our tally of what's going on in Sacramento, and we sort of do a postmortem on what passed and what didn't, what did the governor sign and what didn't the governor sign, we usually sort of cringe and say, how bad was it for contractors? Because as many of you know, California is a heavily regulated state, and a lot of the laws that are being passed are in favor of regulatory protections, and sometimes at the expense of businesses. So we have to sort of look to those laws and analyze them and unpackage those with that sort of mindset. And then we, of course, see with these laws what we can do to sort of minimize the impacts so that we don't get trapped into some of these laws and find ourselves in violations. So with that, I will start. Carlos, how do I start? Where do I go for slides?
You should see a green share screen button at the bottom. And then you want to hit that, and then you should be able to select your presentation when that screen pops up.
Yeah, let me look. I've got screen, I've got whiteboard, I've got Zoom.
Do you see like PowerPoint or anything?
No.
Okay, so you probably need to open the
Yeah.
presentation and then do
Okay,
it.
hold on. I'll open her up.
Okay.
There we go. Presentation. Okay. It is open. I'm going to pop things back up here, go back to share screen, and there we are. Voila. All right. So, and I've got to go to slide review, slideshow from the beginning. Okay. So that's me, new laws for contractors. There's my phone number on there. I'll make the announcement now, and it's also at the end slide. If you have any questions, I hope you'll ask questions during the program, but if you have any questions after at midnight, if you're like me, you wake up at 2, 3 in the morning and think of things. That's what I do. I'm the worst sleeper. 3 in the morning, my ideas pop in my head. You can text, now don't text me at 3 o'clock in the morning, but you can certainly send me a text. That seems to be the way a lot of people are communicating, including me. Send me an email. My email's at the end. If you have a question about something, I obviously don't charge people money to answer questions about things. So don't be shy about asking questions about stuff to me. That's what I'm here for. I'm a huge fan of this program. I think this program is absolutely phenomenal, and the resources that they bring to all of you guys. So I'm just lucky to be part of it. They continue to ask me to come back. So take advantage of all of the resources that are out there through this program, including me, and ask questions and get clarification on some of the things that we're talking about today. So with that in mind, this is kind of what we're going to be talking about today, sort of an overview. New state laws, what came out of Sacramento this past year. Some local laws, not much, but a couple of things to talk about and to touch upon. And then a few things. This is not a COVID seminar. We could do a 2-day program on COVID for contractors. In fact, I think I have. But I just wanted to touch upon some of the big things, broad themes, brush strokes for what's happening in the industry on COVID, just sort of so you know what the latest and greatest is, so that you can be up to speed on those things. So that's kind of what we're going to be tackling in that order. Recap of Sacramento. What did they do up in the state capitol this year? Well, some interesting numbers. I'm a numbers wonk, so I like to follow the data and the numbers to see what's happening. There were 2,421 bills introduced. That was pieces of legislation that got introduced on the floor of either house of the legislature, and 836 of those passed. I thought that number's small, but that's around what it normally is, 35%. And then of those 836 bills that actually reached the governor's desk, our governor signed 770 of them, or 92% of them, into law. California is pretty much a one-party state, so a lot of the bills that are passing through the legislature are getting approved by the governor because of they're like-minded in the sense politically. At least we don't have an impasse between the parties and getting bills through that you do in other states. So those 770 bills are now new laws come January 1st. Fortunately, we're not concerned about all 770 of them. We're concerned about some of them as they impact the construction industry. And that's pretty much what we're going to be talking about today, some of the big ones. New contractors licensing rules. Okay, what do we have on deck now that we have to worry about as it pertains to our licenses? There are some new rules that you should be aware of that pertain to contractors and licensing issues. First one would be AB 830. These are the changes to the RME. Those of you who are familiar with the terms, you have RMO, Responsible Managing Officer, and RME, Responsible Managing Employee, under the licenses. Under the existing law, the RME, and this is sort of loosey-goosey, the RME is sort of this amorphous position about, well, they're exercising supervision and control of the construction operations. They've got to know what's going on with the business. So what Sacramento did is they tightened it up. If you are an RME and they're going to send RME's literature on this and stuff to fill out, you now have to submit an annual statement. So you now have to document everything to the Cslb that is identifying the duties, responsibilities, and supervision of the operations, meaning you have to tell them what it is that you're doing. Before, they were taking your word for it. Now you actually have to document what you are doing. So if you are an RME under the contractor's license, expect to be receiving stuff in the mail from CSLB that is going to ask you to explain your duties and responsibilities and supervision. What they're doing is they're trying to sort of rein in the wild, wild west of RMEs. RMOs are fine. Everybody knows what the RMO does. RMO is responsibility of the license. It's that RME that's, as I mentioned earlier, has been a little bit loosey-goosey. So they're trying to sort of rein that in a little bit by asking you for additional documentation related to that. So another bureaucratic obstacle that contractors licensees will have to meet. This is an interesting one. And this one has been a topic of discussion for the past couple of years, pre-pandemic. Pandemic slowed it down, and now it gained force last year. AB 607 is the license bond increase. All of you who have contractors licenses, whether it's a C license, an A license, or a B license, you have to have a bond. Nowadays, it's so easy. You go on the computer and fill out an application and usually pay a very small fee, and you get a bond. It's pretty simple. Those bonds, when I got into this business, tell you how old I am, those bonds used to be $5,000. In the really old days, they were $2,500. They went from 5,000 to 7,500 to 10 to 12,500 to 15. They've gone up $2,500 in increments. Every 3-4 years, they would go up a little bit. Last year, CSLB undertook a major campaign, an education campaign. I got solicited by CSLB for my input on whether or not the license bond should be increased. $15,000 just isn't a whole lot of money anymore. So the bonds are going up, but it's not going to be effective until January 2023. The reason is they wanted to have an education period and a period of time for the bonding companies to be able to get their paperwork in order and invoices and all that sort of stuff. So effective January 1, so what is that, 10 months from now, that $15,000 bond is going to go up to $25,000. What that means for you is your premium is going to go up. So that bond premium is going to get a little bit more expensive when you renew that bond every year, but there's now going to be a $25,000 bond. Practically speaking, for me, what that means is there's now a little bit bigger of a target on your back. Because before, when the bond was $15,000, if somebody wanted to come after a contractor, they usually didn't bother going after the bond. You know, I want to chase this contractor for $200,000. What's the point of a $15,000 bond? Now the bond's $25,000. You know, that's not something to scoff at. So we anticipate that we're going to see an increase in claim activity on those bonds, because as the bond amount gets bigger, they become a little bit juicier of a target to go chase. Again, effective January 1 of 2023, you'll start to see invoices. If you're renewing or your renewals come up, the premium will likely be higher because the bond amount is going to be higher. Bond of a qualifier, if you're a sole proprietor, not a corporation, somebody small, and you have to have a bond for a qualifying individual, that is getting a big jump. That's going from $12,500 all the way to $25,000. Again, they're trying to create parity between the bonds, the bond of the qualifier and the contractor's bond. They want them to be equal. So going up to $25,000. So be on the lookout for that. Speaking of CSLB and their increasing power, AB 569 is increasing CSLB's fines and penalties. They're expanding the penalty limit. Before, CSLB was limited. The ceiling on the amount of money that they could go for a civil penalty was $5,000. That has now increased to $8,000. And for those who are guilty of more onerous crimes like aiding and abetting a contractor, an unlicensed contractor, that's the big one we see with aiding and abetting. You're licensed, someone else is not. You're allowing them to use your license to go build and then getting a kickback, some sort of conspiracy, aiding and abetting violations. Really a steep increase on those penalties, going from $15,000 to $30,000. CSLB has been cracking down a lot on monkey business with the licenses. So don't ever allow anyone who's unlicensed, oh, my license, I'm in the process of getting my license, but I got this great job. Can I just use your license? They are really cracking down hard on those, not only on civil penalties, but also referrals to the district attorney's offices for criminal prosecutions. So really be weary of anybody who's coming and saying, we want We want to use your license, or let's share a license, or any stuff associated with your license. You worked hard to get that license. Don't let anybody take advantage of it. Home improvement contractors, for anybody who does home improvement projects, that could be a side business that people have. Careful with seniors. The 3-day right to cancel with seniors has now been extended to a 5-day right to cancel for senior citizens. I think we're defining senior citizens very liberally. Most jurisdictions do, as anybody 55 and older. So that 3-day has become a 5-day right to cancel. If they want to get out of a home improvement contract, they now have 5 days to do it instead of 3 days. This dovetails back into CSLB's approach of cracking down on people who are taking advantage of seniors. If there's any stuff going on with seniors, the CSLB is going to be particularly focused on enforcement of any violations, anybody taking advantage of seniors or things like that. DIR, moving on to a fun one, the California Department of Industrial Relations. For those who don't know, DIR is just the fancy way of saying the labor commissioner. That is California's Department of Labor. The federal level, at the federal level, we have a DOL, Department of Labor. California has the DIR. That is the labor commissioner's office, who enforces very aggressively violations of California's labor law, underpayments, missed payments, kickbacks, cash payments that you can't document, paperwork, things of that nature. They are getting very, very aggressive and continue to expand their regulatory footprint over contractors. So we are constantly watching the new laws that are coming out related to the DIR investigations and the powers that they have to enforce those rules and regulations against contractors. It's a very high profile area of law, and sadly an area of law that keeps a lot of our attorneys very, very busy. SB 807 is personnel records. Okay, this one I sort of jammed under the DIR. This is more of a global employment record issue. The old law used to be that employers, and this isn't just contractors, this is employers. This could be a restaurant, this could be a hotel. Employers were supposed to maintain personnel records of employees for 2 years. That was sort of the cutoff. I've got an employee, you're going through employees, are coming and they're going. You've got them, had to have held on to them for 2 years. That was the old rule. After 2 years, you could burn them in the fire. Didn't matter. The new law now is you have to hold on to those personnel records for 4 years. The reason being the statute of limitations to make discrimination, hostile work environment claims, sexual harassment claims continues to expand. And so the legislature wants to make sure that the records related to those employees are kept for a proper period of time. And that is now 4 years instead of 2. But there's a kicker on that. And the kicker is, if a complaint has been filed, and complaint is loosely defined, it could be an administrative grievance, it could be a lawsuit, could be an investigation. If there is a formal complaint that has been lodged against you related to that employee, you have to retain the records until there's a resolution of that complaint or the statute of limitations runs. And the reason that's important is because that could be more than 4 years. If there's a pending grievance or a procedure, don't get rid of anything. Best practices are paperwork, paperwork, paperwork. Hold on to employee personnel files. If you think an employee is going to make a claim, an employee has gone to HR, there's an investigation underway or something, don't get rid of paperwork. You want to hold on to that paperwork until the resolution of that claim has occurred. Seeing a lot more of these employee claims now, and in reaction to that, the legislature is really pushing the documentation angle for employees, contractors and non-contractors. They want you to have good paperwork to be able to prove it wasn't a hostile work environment. The employee made a claim, we investigated it, and we closed the claim because there was no finding. Or we did the investigation, we found out that something's wrong and we fixed it. They want to see the employee paperwork. So make sure to hold on to that. Electronic records for contractors. Now we're specifically getting into what do contractors have to do. These rules have changed and these rules have become more onerous. We're talking really about certified payroll reports. A lot of contractors, public works contractors, are getting pinched because they're not following the rules or staying abreast of, or don't have an experience level or of a knowledge regarding CPRs. If you are going to be a successful public works contractor, you have to get very skilled at certified payroll reports. Everything's electronically uploaded now. They've made it a lot easier, but you've got to know how to navigate it and you've got to do it. So this new Electronic Records for Contractors and Subcontractors Act, this new law, changes the labor code. It basically says that you have to be submitting certified payroll reports every 30 days, period. And folks, the only reason they're making this law is because a lot of contractors aren't doing it. They're doing it when they feel like it. They're doing it here and there. They can really pinch you for this. You have to get those records in every 30 days like clockwork, as long as work is being done on the project, and then within 30 days of final work on the project. If you're finished on the job and you're just waiting for retention and you're done, get your certified payroll reports uploaded and finished. Just get it off your hands. Get you a clean break all the way to retention and getting paid your retention. Don't give the owner, or if you're a sub, the GC, a reason to jam up your final progress payment or your retention by not having your certified payroll reports. They can come after you for violations. The labor commissioner can, if you don't get your payroll reports in. Have to be electronic. I've got a lot of contractors who are old school that still actually have pencils and write with pencils. Everything's electronic now. It needs to be electronic.
Hey,
you have to
Colin,
furnish certain, yeah.
we have a question. Sorry.
Oh, sure.
And Akani, did I say that right?
Yes, Anakani, thank you.
Yeah. Oh, we can't hear you.
Can you hear me now?
Yes, now we can hear you.
Thank you so much. So in regards to the certified payroll reports, I was under the impression that we're supposed to be submitting them on a weekly basis, not on a monthly basis. So that's the change from weekly
We
to monthly?
submit them on a weekly basis. No. We're talking about people who aren't even submitting them on a monthly basis.
Okay.
Submitting them on a bi-monthly basis.
Okay.
These are the outliers. We're seeing it particularly with the trade contractors who just don't want to do it, and they're not getting their paperwork in. So those are the folks that this is really about. People who are submitting them every week, no problem. Great. You're ahead of the game. That's best practices. Okay. So continue to do that. The thing with, and Carlos and Rosa are tired of hearing me say this, the key to being a good public works contractor is paperwork. If you get good at paperwork, you're going to get paid faster. You're going to get your subs and vendors paid faster, and you're going to get done with your project faster. You're going to get your retention faster, and it allows you to close the job and move on to the next job, your next profit center. So this is what the legislature is saying. Contractors who are bad at paperwork, get your act together. Submit it every 30 days. And here we go with the penalty. Here's the hammer. If you don't do it, you're now liable for a penalty. They can charge you. And I've seen them charging people $100 a day, up to $5,000 penalty for not getting your payroll reports in on time. You do get a grace period, but nonetheless, they're still going to come after you. Only accruing to the actual contractor, subcontractor who failed to submit the records. The one saving grace of this is the penalties are only going to flow to the guilty party. They're not going to hold the prime contractor responsible for their mechanical contractor not getting their payroll reports in on time. Employer wage theft. Big thing for the DIR continues to be the attack and trying to remedy our underground economy. The construction underground economy still continues to be very robust, and it hurts legitimate contractors like you, because you're the ones who ultimately have to pay. It adds a section of the penal code which makes intentional theft of wages in the amount greater of $950, or so they've raised the amounts that they can hit you for grand theft, meaning they can refer you to the district attorney's office for greater amounts of money. And the prosecutor can charge it as a misdemeanor or a felony, which means there's now criminal sort of issues attached to this sort of wage theft. So they're raising the amounts of money that they can go after, and they're putting this increased criminal element associated with it, allowing them to go after you for these. Oh, big one here. You got to spend a few minutes talking about direct contractor liability. So a few years ago, I think it's been about 5, the law changed, really pushed by the trade unions, the labor trade unions. They enacted basically a new law in California, and California is one of the only states that has this law that basically says the general contractor on a private or public job is ultimately responsible for the unpaid wages and benefits of the subs. What does that mean in English? What that means in English is if you're a general contractor under the new law and you don't, and you pay your sub $100,000 to finish their trade work, and that sub doesn't pay their vendors, their laborers, their subs, and then closes the shop down, you will have to pay that $100,000 again. You're ultimately responsible for the payment of their vendors and suppliers and subs. Excuse me. This applies to private and public jobs. This was like a wake-up moment for a lot of contractors to say, why am I being held responsible? Why do I have to guarantee the payment to my subs and suppliers? And the reason is, in the eyes of the legislature, you as the general contractor are the mother hen on the project. You are responsible for the money. You shouldn't be paying that sub that $100,000 if they haven't completed the work. You shouldn't be paying that subcontractor the $100,000 if they haven't uploaded certified payroll, or provided you with lien releases, the statutory releases, or given you warranties, or done any of those things. This law really changed the way that we looked at projects now. It forced everybody, especially in the general contracting side, to say, we have to get better about paperwork and we have to stay ahead of the money with our subs. That was the law. That was the law a few years ago that was passed. 727, the new law, expands this law to not just the wages and benefits, so fringes and things like that. I've got one right now. I'll give you an example. I've got one right now where the general contractor finished a project, paid their sub, paid everything, 100% closed out with their sub and moved on. The union didn't get paid the fringes. So the union came after the sub, and the sub's out of business, and the union came after my client under 218.7. And guess what? My client now has to pay twice because that sub didn't pay the union. Bad enough. That's bad. Now we're expanding it. We're making the law even more broad to cover not just wages and benefits. We're talking about penalties, liquidated damages, unemployment insurance, so penalties associated with not having the right insurance, and workers' compensation violations. This law stinks if you're a general contractor, because it's expanding the realm of things that you are responsible for if your subs do not pay the people they need to pay. If your sub doesn't carry the right unemployment insurance, the state goes after them, you can be held responsible for that. If the sub doesn't pay the union and the union comes after them for fringes and liquidated damages, which a lot of times the union collective bargaining agreements have liquidated damages provisions, you can be held responsible. Workers' compensation violations, all these penalty things, you are now responsible for as the general contractor on the project. And you tell this law stinks if you're a GC. It's a great law if you're a subcontractor because everybody's going to get paid, but not if you're the GC. So,
hey, Colin, I actually have a question about that.
Yeah.
So I think some of the companies or some of the companies represented here may be subcontractors or be working as subcontractors. How would GCs pass on, I guess, some type of insurance for themselves or some way to make sure that, you know, they're covered if that does happen or something like that does happen?
Yeah. Well, we'll talk about that. I'll get through this and then I'll give you my ideas on how to protect yourself if you're a GC.
Okay.
The bill also removes limitation of liability. So there's no cap on how much that could be. Could be millions of dollars. However, you know, because they felt bad, they put in a 30-day notice to the contractor and the subcontractor. Before you can come after these penalties and fees and all this stuff, you have to give a 30-day notice to the contractor and subcontractor that you want to get paid. You get 30 days before you get sued. Yay. So how do we get around this? It was a horrible law a few years ago, and that's just gotten worse. So if you're the GC, and I get this question all the time, Colin, how do I protect myself from this law? How do I mitigate? We talk about mitigating risk, right? That's the business I'm in. First of all, paperwork, paperwork, paperwork. I'll say it 1,000 times today if I haven't said it 1,000 times already. Stay current with your subcontractors' paperwork. That example that I have right now, we should have known. I told you about that case with the union coming after me. We should have known that that subcontractor was taking on water because his paperwork was lousy. You will know if your subs are not paying their fringes, their workers. You can tell because they're going to get bad at paperwork. They're not going to be uploading their certified payroll reports. If they were, you'd know they were good. Get releases. This is one of my big pet peeves of general contractors, public works contractors. Before you pay that sub, did you get a release? Well, no, why not? Well, he needed the money. I felt bad. No release, no check. The release protects you. It protects your bond. Get all the proper releases before any of that money goes out. Another one that I have in my subcontract agreement that my GCs use is all clear letters from the trade unions. Now, I understand it's hard to get. A lot of the unions won't give them to you, but it doesn't hurt to ask. What that means is before I pay that sub, I go to the union and I say, I know that this sub is signatory with you. Are they current in all their stuff with you? Or are they on your naughty list? I want to know if they're on your naughty list. If they are, I'm not going to pay them. Sometimes the union will tell you, sometimes they won't. You can ask for an audit, it takes a while, but ask. Maybe the union will let you know. Retention. Hold retention on your subs. Please hold retention. You're obligated to hold usually 5% retention on your job. Hold that retention back from your subs. Keep some money back. Stay ahead on the cash. So you have that little nest egg, that little protection against you. And then, of course, an important one, well, I'll save that one for last. In response to the question that was asked earlier, I think it was more contractually, what can the GCs do to the subs? Have indemnity. If your subcontractor is still vertical and hasn't gone out of business, have a subcontract agreement that provides they have to indemnify you from this claim. Make it their problem. If you make it they have to pay their subs. Why should it be your problem? If you have a good indemnity provision in your subcontract, you can wash your hands of it and turn it over to them and make it their problem. That's assuming they're still in business. The bottom one is really the most important one. Because the odds are they're not going to be in business. If they're not paying the union or they're not paying subs and vendors and somebody's coming after you, it means they're probably out of business. Bond back those subcontractors. I am a huge, huge cheerleader for bonds. Bonds have an important place in the construction marketplace because they spread risk. They allow you as the GC to spread that risk downstream, not only to your sub, but to their surety. Remember, you own that risk by virtue of giving that owner a big, juicy bond for the project. Why not spread down and flow down some of that risk to your subs by having them bond you back? I understand there's costs. Bonds are expensive and that comes out of your bottom line on the job. You may not be profitable. You may not get the bid. You have to put in price for that. That's a business decision. But particularly for risky subcontractors, and I use that term loosely, risky subcontractors, I'm talking about people that have no experience, that have no, this is their first rodeo. They're not good at payroll. You know, they don't have good cash flow. They don't have any assets. They're a risk. You want to use them. You like their number. They're good people. Get a bond. The beauty of the bond is when you get into this situation where the union or somebody's coming after you to pay for this deadbeat subcontractor, even if that subcontractor is out of business, their surety is not. You can simply pass on that claim to the surety and make it the surety's problem under the performance bond. So find ways to bond back your subcontractors. If you want to sleep better at night as a public works contractor, one of the main ways you can do that is bonding back your subs. Because by doing that, you've mitigated the risk that they're not going to pay their bills, that they're going to go out of business, that they're going to move to Fiji. You don't know what they're going to do, but it's sure nice to know that there's a surety there to step in and pick up the paces if they don't. Enforcement liens on real property, expanding the power of the DIR to lien property to pay judgments and debts that are owed to the DIR. This is teeth for the DIR. It now says if they come after you for an assessment or a penalty or something, if you owe the DIR money, you don't just get to throw it in the trash can. They can come after you for repayment of those, and they can lien property that your business owns, and that lien can stay in place for up to 10 years and be renewed. So expanding the enforcement power of the DIR. Speaking of there's a new, I'm sorry.
No, I'm sorry. It might have been just Matt, but I thought you cut out for a second. It might have just been me. Sorry.
Okay, you guys are still there, right?
Yes.
Okay. There's a new initiative from the DIR that is actually having an LETF, this task force, strike teams coming out to public works jobs. They're actually showing up on projects now, effective in January. I haven't heard of any actually happening, but I know they're coming. And they're walking around the site and they're kicking the tires and they're talking to the subs, they're talking to the workers, and they're looking at workers' compensation to make sure all the subs and the GC have work comp. Are you paying prevailing wages? If there's a skilled and trained workforce requirement, are you meeting it? Workplace safety, they've got OSHA members. Are you meeting apprenticeship standards? Department of Insurance, do you have all the insurance you need? It's a step up. They're really upping their game as far as before they were auditing jobs, from a cubicle. Now we're actually sending members with jackets on from the DIR onto sites, and they're investigating and they're interviewing and they're talking to people actually on public works projects. I don't know how much of this is actually going to translate into increased penalties, but it is something for everybody to be aware of. You may see government representatives, not inspectors and things, but actually people from the state of California walking around your projects, interviewing people. They're going to be doing more and more of that now, trying to address these safety violations and underpayment violations and stuff like that. Minimum wage, everybody should just be aware. I hope everybody is, that minimum wage laws changed in January. It continues to go up. LA has its own minimum wage ordinances. So those are more, I want to say it's 1604 or something like that. It's a funky number. But be aware that minimum wage in California continues to go up. I think we're in a business where we don't get to employ a lot of minimum wage workers because of how expensive everything is, but understand that minimum wage does continue to go up. In this supply chain world now, I don't know many businesses that are paying minimum wage anymore to attract talent, but it is getting more and more expensive, the labor market these days. Bidding and procurement, a few items. Just to understand, when I say procurement, I'm talking about how the project is delivered. California continues to move away from hard bid, the low bid contracting, which is design, bid, build. Owner hires an architect to draw it. It goes out to bid, and then whoever's the lowest bidder who gets the job goes out and builds it. They're constantly finding ways to get around that. Job order contracting is one of them. They use that a lot in the federal system. For any of you who do federal public works, JOC contracting. School districts can now do JOC contracting K through 14. It's extended it through 2026. There's a pilot program for it. It's been extended. However, what you're going to see in a lot of these alternative procurement tools is something for the unions. And I'm not anti or pro union. I represent contractors who are both. But most new laws that are allowing alternative delivery options for public works construction have some form of union component to it. California is a very labor-friendly state. The JOC contracting is great. You can use, school districts can use it, but it adds you got to use a skilled and trained workforce requirement. However, that's exempted, and you're going to see most skilled and trained workforce requirements exempted if there's a project labor agreement in place. For those who aren't familiar with skilled and trained workforce, it's essentially a commitment to use a trained, apprenticeshable craft labor on your projects. Doesn't have to be union, but a lot of times it is, because most of the programs approved the Division of Apprenticeship Standards, the DAS, are union programs. So you're going to see more and more of those these alternative delivery systems, the door open to school districts using them, or other public entities using them, as long as you're using union labor. Leaseback, same thing with leaseback. Leaseback is a school creature for school districts to build schools without having to go out to public bid, meaning they don't have to pick the lowest bidder. They do an RFP, or request for proposal process. There's been a lot of legal challenges to leaseback over the last 4 or 5 years. The legislature reaffirmed the use of leaseback, and they've now extended it for another 5 years. So it's out there. However, there's additional components that you have to do a competitive solicitation. You can't just pick your best friend down the street to build your school for you. We're worried about that in smaller districts, parts of the state where there aren't a lot of contractors, the same contractor getting the job over and over again. You have to actually solicit someone. And of course, with leaseback, what is required now as of 2 years ago, skilled and trained workforce requirement. So they added that into the law a couple of years back. Change orders for LA County. If you do any work for the County of Los Angeles, this only matters tangentially because typical law is public owners are capped at 10% on change orders. They usually have to go back to the board or the city council or whoever the ultimate agency is to get approval for change orders. This is going to allow the County of Los Angeles, not the city of LA, the County of LA, to have increased individual change order approval at the local level, meaning not having to go to board. And the idea being the Board of Supervisors doesn't want to deal with, an agenda full of change orders. So I'm watching this one because I think this may be sort of a pilot for whether the legislature is going to expand the change order allowances for all public entities. It's really a pain in the rear to have to go to the board every time you want to get change orders approved. However, that's in place for the protection of the public so that jobs don't run away on change orders. It was a $5 million job, but with change orders, it became a $10 million job. The taxpayers aren't really going to be happy about that. School bonds, just so everybody's aware, if you do any school construction or you watch school construction, this filters down into regular public works because everything's interrelated. There are right now pending in Sacramento 2 competing bond measures. If you remember pre-pandemic, I know it's hard to remember that, March of 2020, we had Proposition 13. That was the one that had the weird title on it that nobody knew what it was because they thought it was Prop 13 with property taxes. That was a school bond measure that went down in defeat. That was the first statewide school bond measure that had been defeated in California in a very, very long time. So they are back. The folks wanting to get more school bond money is back. And we're doing now, there's 2 competing measures, one in the Assembly and one in the state Senate. AB 75 is 12 billion with a B. That is a lot of money. 12 billion in general obligation bonds for K through 12 and community colleges. So that's basically K through 14. 12 billion for K through 14. There's another one, SB 22, which is 15 billion, again, billion with a B, for general obligations bond for K through 12 community colleges, so K through 14, and CSU and UC. So the reason there's competing measures is because there's competing schools of thought about, can we get the bond measure? AB 75 people tell you, well, I can get 12 billion approved if I don't include CSU and UC because the Cal States and the UCs torpedo my bond measures. The voters don't want to give money to the higher edge, to the colleges, the higher, the bachelor's degree level colleges. The SB 22 people say, no. Without the Cal States and the UCs, you're not going to get AB 75 passed, so we need to include them. So they're arguing and they're going to wrangle it out and figure out what's going to be on the ballot. One of those 2 will be on the ballot in November. And the reason that matters, even if you don't do schoolwork, is that it's going to focus a lot of public works attention on school projects because it takes a year or 2 for that money to start flowing. But assume it's the lower one at $12 billion. That is a boatload of money. The CMs are going to want to go after that. So you're going to see a drain on the construction management companies. They're all going to be chasing to go do that work. The architects are going to want to draw schools. They're not going to want to draw fire stations because that's where the money is. So we're going to be watching real closely to see, again, that has to pass in November, and who knows if it will. If it passes in November, that'll be a major cash infusion into the schools, and it's going to divert construction resources into schools. So that's either going to be a good thing or a bad thing as far as opportunity for other areas, but it is going to move resources away into the educational arena for construction. So that's why we're watching that very closely to see what happens there. COVID-19. Let's talk about COVID real quickly. Lot to talk about with COVID. Interestingly enough, before we get to that, I didn't include a slide on this because it's not all that relevant, but the court systems, the world that I live in, the LA County courts, which is the largest trial court system in the country, and the Central District of California, which is the largest federal trial court in the country, both announced that they're back to full speed. One was February 14th, Valentine's Day, and one was I think it's yesterday, that they're going back to full, normal, regular operations. So that doesn't seem important, but it really, really is in the bigger scheme of things, because what that means is for the past 23 months, the courts have largely been closed down. They've handled some criminal trials here and there. They've tried to make do with some remote. We've done some trials remotely, but there is an incredible backlog of cases that need to work through the court system. And so why that matters to contractors is because I have a number of contractors who are chasing money, who are owed money that should have gotten their day in court 2 years ago, that are now just going to get their day in court. So justice delayed is justice denied. It makes it very hard if you are owed money. And the reason I'm bringing this up is that if you are owed money by somebody, an owner, a general contractor, you're chasing money to get paid on a project, you are going to be waiting a lot longer to get paid, because there's such a kink in the hose as far as getting the judicial system back up and running into normal, that those cases that should have been resolved 2 years ago now are getting resolved. So where are you if you go chase money now? You're really at the back of the line. So I have encouraged a lot of my clients who are owed money to try to find alternative ways to get that money. Increased use of arbitration clauses in contracts, mediation, which is the parties just sit down and they try to work it out. It's not binding. Settlement negotiations and meetings and things like that, trying to resolve your construction disputes outside of the court system, simply because the court system now is going to take so much longer until we unkink the hose and get things flowing again. So that's my editorial on our court system. COVID-19, all I wanted to say about COVID-19 was there's a couple of new rules that you guys should all be aware of, not major watershed events like we had a couple of years ago, but just things that should be on the radar. If you have an outbreak, and what does everybody guess an outbreak is defined as? It's three or more people. You are supposed to report that to your local health agency. So if you are in the office working and 3 or more people come down with COVID the same day and they all tell you we all got COVID, you're supposed to notify the local health agency. Let them know within 48 hours or 1 business day. There are notification requirements. A lot of people don't understand that there are. And if you don't, you can get pinched for that by the agency. The labor department can come down on you, the DIR, for COVID violations. And I've seen it for not notifying the authorities that there's been an outbreak. I think three as an outbreak is a little silly, but that's what they define it as. Supplemental paid sick leave law. Okay, this one gets even more complicated. If you all remember, when COVID started, we had supplemental paid sick leave that was implemented and then it expired. It sunsetted in September. What that meant is after September, when we all said, yay, nobody knew what Omicron was, we all waved our hands in the air and said, COVID's over, it's great. They allowed the supplemental paid sick leave law to expire. What that meant is from September up until this law was passed, if someone got sick with COVID, you did not have to pay them. They burned through their sick days. They didn't come back. You didn't pay them. You didn't have to go out of pocket to do that. Then Omicron hit. We got the uptick through December and January, and they passed this emergency legislation that became effective, last week. Essentially says if you have 25 or more employees, so again, this is going to be for more mid-sized to bigger businesses, You have to give paid sick leave to people who can't work. And this is a big one. I should have underlined it. Or telework. They're at home. They can telework. They can telecommute. They can get on their computer and still work. That's still working. But if they can't work or telework, meaning they're sick because of COVID-19, and we're going to talk about what that means, they still have to get paid. You can't not pay them. Now, I've been telling people best practices, even after that law sunsetted in September. It's just good business practice to pay your employees when they get COVID. And the reason why is the Great Resignation. We have never seen in the history, I think they said in the history of our workforce, we have never seen this many people leave the workforce at this rate. There's such high turnover. There's such a lack of loyalty in businesses now that you will lose workers. So the concern is if you stop paying people because they're sick, which the law allowed you to do come the end of September, you will lose employees and nobody can afford to. I know I cannot afford to lose employees. I'm sure you can't either. So what we have is if you're either sick or you have to stay at home to care for family members impacted by COVID-19, this law is going to apply to you. And that's important because what we were seeing in our office and with a lot of our clients was the husband or wife, the parent did not have COVID, but something happened at their kid's school. A teacher had it. One kid in third grade got it, so they shut the school down. They sent everybody home. All of a sudden, that spouse can't work, that parent can't work anymore. They have to stay at home to care for the kid who's now at home because they can't go to school. The new law says now you need to pay them for that. You can just means they can use up existing sick time, but you can't not pay them. So here's what they did. They got real creative with this. I thought this was interesting. They did sort of two banks of time, and it's 2 weeks, 80 hours in two banks. The first 40 hours is supposed to be for COVID related issues, meaning I have to care for my kid. I got to stay home this week because my kid's school is shut down. I got to care for grandma who's sick, who got COVID, or had to leave the nursing home because they had an outbreak or something. That's the first 40 hours. The second 40 hours is I stayed home with my kid for the week, came back to work, everything's fine. Then I got COVID. Now I got to stay home. 40 hours and 40 hours. They get two tranches of sick time that you have to pay them for. It's 80 hours, up to 80 hours. That could be steep if you're a smaller business. Although effective February 9th, when I say 2/19, February 19th is when it became effective last week. It's retro to January 1st. Back then, anything going forward from January, you have to cover. It is capped, and here's the good news, at $511 a day or $5,110 in total. You don't have to go out of pocket more than $5,000 in paying people who are out sick. So here's what that means. I'll tell you what we're doing. So we had kind of an outbreak of sick people. I don't want to use the term outbreak, but we had a number of people that got sick in January, came back from the holidays, partying, New Year's. First week back, we lost like 3 or 4 people to COVID. They went out. There was no law back then. They burned through their sick time because we give everybody sick time. What we're doing now is going back, and if they have exceeded their sick time, we are replenishing their bank of time. Meaning if they took 5 days off, they burned through their 5 days, they still got a paycheck, did not pay them. We are giving them 5 more sick days because the odds are come August, September, October, November, we get into the latter part of 2022, people are going to get sick again, and we don't want them to be out of time. So best practices dictate, don't punish your employees who either had COVID or had to care for a family member who had COVID. They can burn through their sick time, that's fine, but don't not pay them. If you don't pay them, you risk 2 things. Number 1, them leaving, and number 2, them filing a COVID grievance with the state of California. And you do not want them because because they're going to investigate you. So I'm really encouraging people not to punish employees, legitimate COVID employee, situations. People have been asking me about, well, whether I can demand a test. We are offering testing. If you do testing, do it at your expense, but it is not required. Meaning you can't say, bring me a doctor's note that says you have COVID. We're not doing that. If there is a good faith representation from them that they either have COVID or are caring for somebody that does, qualify them for the supplemental sick time, and do not punish them by not compensating them, because that will likely result in a grievance to the labor commissioner and an investigation that you do not want.
Colin, we have
yeah.
one question from Jean.
Sure.
Okay, thank you. I was waiting to see if you would answer this question, or if it would come up. It's regarding public housing, renovation and refurbishing of public housing, particularly Section 3. Are there any laws concerning public housing using or PLAs, making sure that there are PLAs on public housing projects?
No, there is no, every individual owner determines whether or not a PLA will be covered. So that would have to be approved by, that procurement would have to be approved by the particular board. There is no application for PLAs broadly across public housing. The particular bid or procurement for the construction of that housing may have a PLA component. I don't know. It would depend on the specific program.
Okay, thank you.
So COVID-19
do-
best practices, and I really want to implore people, the way you're going to stay out of trouble with COVID, I don't want COVID to become an employment issue for contractors. And the way to avoid that is, regardless of business size, even if you're a small business, don't discriminate against somebody or that has COVID or has to deal with COVID. And I don't mean discrimination like you're intentionally doing it, but you're accidentally doing it by not paying them or allowing them to be compensated because they're at home taking care of somebody. We do obviously have to watch out for the employees that are abusing the system. But honestly, if you have employees who are abusing the system, they're probably not good employees anyways. And at some point, you're probably going to get rid of them. But don't make COVID the fight. We don't want COVID to be fight. Exercise flexibility with your employees, particularly those that are caring for sick family or have to stay home with their kids. I can tell you it goes a long way with employees that have children or that have maybe grandma living with them or something. If they have to take care of them, or if there's a COVID related issue with the caretaking, give them flexibility, allow them a period of time to telecommute. Again, we mentioned in the law, the telecommuting, it's allowed. You certainly don't want to open the door potentially to a situation. I had this come up yesterday with one of my general contractors, where they were worried that the minute they allowed this employee to telecommute, that they'd never come back to work. Set the confines on what that's going to be. We understand that your kid's school is closed this week. We understand it's a difficult time. Work from home. We bought somebody in our, we bought one of our file clerks who needed to work from home a laptop and hooked them up and said, it's a company laptop, but go work from home. We understand that it was a nephew or somebody was sick. Give that flexibility to your employees, because if you do that, not only are you going to create a good, healthy, positive working culture, you're also going to avoid those COVID claims, which may rear their ugly heads in another year. You're not going to see those claims for a long time. You're going to think you're fine. And then all of a sudden that employee is going to leave and say, I didn't get time, I got punished. We don't want to punish somebody for having to deal with COVID. What we want to do is compensate them, but with a balance of not bankrupting your business. Obviously, you need people to come to work and do all those things so that they can continue performing their work. But exercising that flexibility is critical during this time. We also don't know what the new rules and new laws are going to be. There's going to be a relaxing. Speaking of relaxing, the masking requirements. Oh,
before you move on, we have
Okay.
one question.
Sure.
Thank you. This is Lanak Hanna again. In regards to the COVID testing, I'm sorry, just needed to clarify. You mentioned we do not have to require the test if employees claim that there was a COVID case at home, right?
Correct. Yeah, you would unless it's pretty clear that it's being they're lying to you. You can test, and they don't have to share the results of the test. That would be a HIPAA medical privacy issue. If you are asking your employees to test, just make sure that you are paying for it. They should not go out of pocket for a COVID test. That is one area of law that we have to be sensitive on. The employee should not be spending money on a COVID test.
Okay, so you mentioned, good faith representation. I had a specific case with one employee who said he was exposed to a COVID case at work, and so he was excluded from work, right? So I sent him home until he tested, and first he said my test came back negative, and then he said no, it was positive, and then negative, positive. So as of today, I don't know what it was. Because then it went into a complication with his wife also had COVID. So, I mean, it's just that one employee saying yes and no, yes and no. So regardless, right? If I'm not going to be asking all of the other employees, I shouldn't ask him. I should just give him that pay for those days.
Well, yeah, but he can't keep saying negative, positive, because sooner or later he's going to be out of a quarantine period.
Yes. And so
if he's gotten out of if enough time has passed between, the quarantine periods keep changing. It was 7 days, and then now it's down to 4 days. Right. If he keeps telling you, if his exposure, what is today, Wednesday, if his exposure was last Wednesday and he keeps telling you I'm negative, I'm positive, he needs to get his butt back to work, because he has now his exposure period of time that, let's assume he was positive on Wednesday and it's been positive. He's out of the woods now and he needs to come back. Right. If he won't come back and refuses to come back to work, then tell him to get a COVID test to show that he's positive. And if he refuses to do that, you've already given him a week off. You've given him 40 hours to deal with. Again, we're watching the time here. You've given him 40 hours to deal with his own illness. He doesn't need the second bank, because he's not watching after a child or grandma or anything like that. He should be coming back to work.
Okay. And then, so these are for my employees on the field, laborers, members of a bargaining agreement. Their hourly wages are usually, prevailing wages. But I also have a pool of employees who are not my core employees. They're not my permanent employees. So let's say I had this one person, she had not been working for over a month. I don't necessarily call her to work all the time. Mm-hmm. I was called for a specific number of employees one day, so I needed additional manpower, and I call and ask, are you available to work tomorrow? And her response was no, because I have COVID. So I will pay only for the one day that I will have sent them to work?
Yes, you only pay the time that they were. Did she actually show up to a site and work, or no?
No. When I called her to see if she was available to go to work the next day, she said no. Mm-hmm.
Okay. So why would you pay her for any time? She didn't perform any work.
Okay, no, yeah. I mean, I was thinking like, oh, she would have worked that one day if she had not had COVID. That's how I was understanding it.
Oh, you're saying because she had COVID, you want to pay, but I don't think you could get punished by the labor commissioner for that, because she never actually worked.
Correct. Okay, perfect. So I just needed to clarify that. Okay, perfect. Thank you.
So I'm almost done, and then I'm happy to take some questions on this, because I'm sure there may be more questions on COVID. It changes every day. Masking rules. Understand the new masking rules. It's crazy. I was up in Santa Clara. Los Angeles and Santa Clara are the only two counties in California that are still requiring indoor masking. If you think LA is bad, Santa Clara is like the dark ages. They're like restaurants or takeout. Masks required. They still have the hand sanitizer. I had to, when I signed the credit card slip, I had to use the hand sanitizer. There's still a few counties that are really dealing with COVID, and you have to understand that just because the California Department of Health and the governor's office released the mask mandate last week, that some counties, including Los Angeles, still have those in place and still have the authority and the ability to mandate that. I know some people have said I had somebody argue with me that this is ridiculous in LA. Why I can't, I have to wear a mask in LA, but I don't when I drive up to Bakersfield or down to Orange County. That's the way it works. I think those rules are going to start to get relaxed more in those counties in the next few weeks. But until then, you relax the indoor masking requirements. Keep in mind, and here's the rub, I know we're dealing with this and a few of my clients are, it's for vaccinated individuals. How do you know if somebody's vaccinated? You can't ask for, we're not asking for vaccine cards around the office, self-attestation, saying, are you vaccinated or not? It's if you know that's if it's your office and you know that people are unvaccinated, they are supposed to be wearing masks. Again, outside of LA County, depending where you are, LA County still masks. Schools, another sensitive topic. We know that schools are still going to have masking until the end of February. My guess is by March. Well, LAUSD just announced masks are off outside. We're going to start to see masks coming off indoors at schools probably in March. But until then, whether you love masks or whether you hate masks, we still have to follow the rules. And I know it's frustrating for your business because the rules keep changing and it's jurisdictional. One rule here, different rule there. We're almost through into the warmer weather. And when we do, I think we're going to see a relaxing of all these requirements, but follow them because you can get pinched by your employees if you're not following and enforcing your masking rules. What we did last week when the new rule changed is we sent out a note to all of our employees and we sent a copy of the Department of Public Health. If you're interested in what the rules are, a great resource for the most updated rules is the California Department of Public Health website. So what we did is we sent all of our employees a link. We said the rules change effective 2/16. Here are the new rules. We cut and pasted it from the Department of Health. Go to the website and read what the rules are. There's a whole bunch of different stuff. Let them understand by reading those rules what they are. Don't try to interpret them for them. Explain that, if depending on you're outside LA County or Santa Clara County, that the new rules are this. And if you want more information, go to the California Department of Public Health. I mentioned the courts. So what else? Questions? I kind of raced through some of this stuff, so I'm happy to answer questions with the time that we have left.
Colin, Naveed here from the program. Thank you so much for this very informative workshop. You do this often for us, and you really bring a wealth of knowledge to our participant contractors. So we really appreciate it. A few questions, if I may, because these are stuff that we've encountered and stuff that our contractors have asked us. COVID-19 waivers on payment and performance bonds. Are those effective in the sense that can they be held up in the courts? Let me put it that way. In other words, because
when you say COVID-19 waivers, what do you mean?
So we've seen on at least one specific occasion, a bonding company issue payment performance bonds and attached a COVID-19 rider. I'm sorry if I said waiver, a rider. Mm-hmm. And essentially, when you read the rider, and I'd be more than glad to share it with you, mm-hmm. it almost defeats the entire purpose of the bond. It basically says, due to COVID-19, everything is fluid, material costs can change, nature of rules around what work can be done, cannot be done, can change, and goes as far as to say is we won't be responsible for liquidated damages, basically negating a lot of the provisions that the guarantee the bond was providing in the first place was offering. Have you seen that? And
I saw one. I think I know the surety you're talking about. It's a big one. I've seen one. I haven't seen a lot. That was a performance bond. I saw it within the performance bond context, and my reaction to that one was, and my position hasn't changed, what owner would ever accept that bond form?
Right.
Most smart owners would reject it. They have the right to reject it. But legally, if the owner accepts that performance bond, the terms of the performance bond would govern, and that could potentially hurt the owner and limit their right to recovery against the contractor. Now, my answer would be different for a payment bond. Not as much applicability on a payment bond side, but payment bonds and performance bonds are viewed differently in California. Payment bonds are usually what we call statutory bonds. They're required to be given by law and are viewed more strictly. So I would say any language like that in a payment bond, I'm skeptical of. Any language like that in a performance bond, if accepted by the owner, I think would be valid and enforceable. If the owner is dumb enough to accept a bad bond form, then they get to accept the outcome of the bad bond form. They should be rejecting them.
Yeah, no, and in fact, that was our reaction too. We were like, well, this has been appended to the bond. Let's see what the owner and the owner of this particular job was probably one of the larger GCs out there. So we were surprised that they didn't balk at it or say, hey, this is not going to work for us. But they've accepted it. So it was.
Yeah, and when we say appended to the bond form, we mean a legitimate rider to the bond form that's got all the bells and whistles.
Yes,
of a right, like a dual obligee rider on the stapled to the back of a bond form.
Exactly.
If the owner accepts that bond form, it becomes part of the contract and the contract documents. And I don't see any public policy reason why that would be struck down or not enforceable. Again, I think if you start monkeying around with payment bonds, you're going to run into some issues. But on the performance bond, absolutely, shame on the owner for accepting the bond form. Good, by the way, good for the contractor and good for the surety.
Interesting. Okay, that was one question. I think you addressed this earlier, but we often get asked on certified payroll reporting. That's only applicable to public jobs or jobs where prevailing wage rates apply, correct?
Correct. The DIR will only accept and upload. It's usually LCP tracker for uploading the certified payroll reports on public jobs. And the way that you get the ball rolling on that is they have to fill out a DOS 100. I think it's the 100 is the form that the owners fill out that puts that project on the grid for the Department of Industrial Relations. They fill out a form that says, I'm building a new fire station for the city of Los Angeles. It will be prevailing wage. Here are the project details. They send that to the state, and the state now puts it on the radar that this is a project, and they input it and they set it up to accept uploaded certified payroll reports. So that typically only happens on public works projects in which prevailing wages are being required. I have had jobs in which they want certified payroll reports. It's private jobs. They're not being uploaded to the state. The DIR could give a hoot about the project, but that particular owner has wage requirements that they want honored. And there's a paperwork requirement associated with that. Those are few and far between.
But at the same time, that new law you mentioned earlier would still apply in terms of GCs being responsible for proper wages being paid, even on private jobs.
If there is a private wage requirement on the, meaning if the labor code is only if the labor code is implicated. If I have a private job and I just say, you know what, I want the workers to get paid $50 an hour, the labor code isn't going to govern that. And you're not going to have to upload. The DIR doesn't want uploaded certified payroll reports from a private job just because you wanted to. It's got to be a job in which there's a labor code requirement for certified payroll reports, meaning a DOS 100 project in which all of that stuff is input into the system.
Okay, and last question, because this comes up often too, and has been a contentious issue, if you will, post-COVID. And I know it could probably be a seminar on its own, but electronic notaries. So both in the context of notaries to bonds, let's say performance bonds, but probably even more broadly and perhaps more importantly on just general indemnity agreements, if you will. What is California's current position on the validity, if you will, of electronic notaries?
California is one of the few states, and there's a great map. I got to find that for you. We looked at this last year when all the notaries were closed. States that implemented emergency notarial acts for allowing electronic notaries. Mobile notaries are fine. We're really talking about electronic notarization. Right. California did not elect to pursue any sort of emergency legislation on electronic notaries. So there is no law in California. I know there is in Arizona and many other states that owners have to accept electronic notaries. California does not have that law. Owners can reject bonds that have electronic notarizations on them. I've seen owners reject bonds for all sorts of reasons. There is no rule that says you have to accept that in California. Mobile notaries are different because that's an actual notary
Yeah.
coming to your house
Yeah.
and doing it. Be careful with electronic notarizations, especially when it comes to bond forms, because many public owners will reject them. Sureties are different. I think that's an underwriting by underwriting, case by case basis as far as what they will accept for the notarization of the bond form. The surety will accept an electronic notary, great. It just depends on who the surety is and whether they'll accept that or not. I was surprised, given how progressive California is, that they did not move forward with an electronic notary act, a universal electronic notarization. It's interesting to me because what we're seeing now with liens, there's new outfits like we use Simplifile, which is a new recording service. In the old days, you actually had to fill out a lien and handwrite it and submit an original wet signature, have it carried over to the LA County Recorder's Office in Norwalk and recorded and all that. Everything's electronic now, and most counties have come online to that. So it is surprising that California has not moved forward with electronic notarizations. Maybe they will, but I'm not aware of any new legislation that's changed the landscape related to mandatory acceptance of electronic notarizations.
Yeah, no, thank you for that. And I would just add very quickly for the contractors in participation today, because we get this question all the time, is know the procurement policy of the owner you're submitting a bid to, because as most of you probably have witnessed, a lot of public agencies are now willing to accept bids in an electronic fashion. There's a lot of different portals right now that are making it conducive for public agencies to accept your bids, bid bonds and the like, including your bonds in an electronic capacity. But there are owners, I know of one in particular in Los Angeles, that has not come to that. And one of the reasons I've heard is particularly because they're not comfortable with an electronic notary. So just want to put that out there.
And I'll build off that one step further. I've been seeing a lot of bid protests of late related to incomplete, deficient bid bonds. Bid bonds are one area in which I think sometimes everybody gets sloppy because it's just a bid bond. So I've seen a number of bid protests that have fallen on deficiencies within the bid bonds. And the problem with that is a lot of times they're small deficiencies and they can be waived by the owner, but it doesn't mean they have to. So if you get your bid done, your takeoffs, your pricing, everything's beautiful, the surety's on board, you got your subs listed, they open and you're low and you're excited, and then you get a bid protest because there's a deficiency in your bid bond, that owner can choose to accept that protest and not waive the defect in your bid bond. Yeah. A lot of times they do, and they'll just say, it's a minor issue. But sometimes they don't, especially if they don't know you and maybe they want to work with the number 2 or number 3 bidder. So it's just an opportunity to really look closely and make sure that you're dotting all the I's and crossing all the T's on your bid bonds, because it is one area that yields a lot of bid protests.
Yeah, thank you for that. And again, thank you for the wealth of information you shared with us today. Appreciate it.
All right, do we have any more questions?
Carlos, did we cover everything in the chat? I know there was a chat stuff up there. Did we get all those?
Yes, that was just
good.
me.
Oh, it was you. All right.
Yeah, we covered everything.
Okay.
I don't see any more questions. I would do one last call. Is everyone good? I know there's a lot of great information. I learned a lot today.
And like I said, that's my cell phone number. You can text me if you have a quick question, or shoot me an email if you've got a longer one. I'm happy to answer them.
Okay. Yeah, sounds good. So yeah, definitely take him up on that offer. If you do reach out, please just mention that you attended this training, because I'm sure you're not the only one that's asking questions and for information. So please do that. If there are no other questions, I just wanted to share really quick our contact information here for the Contractor Development and Bonding Program. Once again, if you are enrolled, please reach out to your account manager and make sure you're keeping that relationship going. If you're not, please give us a call or email and ask for more information. We do trainings like this every month. We have a 5-week bidding and estimating training academy coming up starting next week. And then we'll do 2 more this summer and fall. So we have a lot going on in regards to training and information. So please take advantage of it. And really the only requirement is for the most part, that you have to be enrolled in the contractor development and bonding program at no cost to you. So if you're not, please take advantage of that and just give us a call and contact, and we can give you more information. With that being said, thank you all for being here this afternoon. Colin, thank you so much. You're so great for our program and just bringing this information to us, and we really appreciate your partnership. And if there's anything we can do for you, please reach out. Everyone have a great rest of your evening and be safe, and we will see you next time.
Thank you.